Hi, Darren Mangum here, securities lawyer with the law firm of Mangum and Associates. Thanks for watching my YouTube channel. Today, I wanted to comment on the huge news from the Supreme Court. Not just with the SEC, but I'm talking about administrative agencies in general have reason to now fear that their days of having administrative law judges are over. This is the case. SEC versus Jacarsi, huge watershed case. Basically, the SEC has said that the administrative courts are unconstitutional. Just you can't do it. I mean, administrative courts have been around probably for a long time, at least 40 years, and the problem is that, well, according to Justice Thomas or Justice Roberts, who penned the majority opinion, and in this case, the SEC. It says he wrote that the SEC's reliance on in-house judges and courts violates the Constitution's guarantee of a jury trial when the agency is seeking civil penalties for fraud. The court did not take up other issues. This is major, right? Unconstitutional, right? Constitution guarantees a jury trial. So the problem with administrative law judges, they're appointed. These judges were before this decision, and we haven't really seen the fallout of this yet. But we're seeing that they're saying that these judges are not independent, and that's been really a criticism for these administrative law judges. For years, right? They're employees of the very agencies that are bringing the cases, right? And so now, obviously, these administrative law judges are highly specialized. They understand the agency's rules. They're interpreting the agency's rules. Supposedly, they're independent, but all the ones that I've ever seen, they've been criticized for being a rubber stamp for the agency, right? And rarely do you get an administrative law judge that goes against the agency that employs them, right? I remember a case, well, back when I was during law school, I did an internship at the SEC's office in Los Angeles, and we brought a case against a broker for selling bonds to an investor that were not deemed suitable, right? For those high risk bonds, and also the commission rates were very high, and so the agency was bringing an action instead of bringing it in a federal court, like you would normally think, that where you'd have the right of a jury trial and all that. They would routinely bring these cases before an administrative law judge. And I remember talking to the attorneys on the other side, and they're like, "We hate these cases. We always lose them. It's not fair. It's not independent. You don't have an independent judge looking at this, and it's basically just a kind of a show trial, kind of like they do in North Korea, right? Where the government appoints the judges, and it's like, okay, they're just going through the motions, and 99 times out of 100, the administrative law judge is going to say, hey, yeah, they side with the SEC, right? And so in this case, for years and years, they've been criticized for just kind of rubber stamping the agencies. And this opinion, while it's directed at the SEC, I mean, what about all the other administrative agencies that have their own administrative law judges? I mean, that's why I'm saying this is a major case and a major blow against the administrative state, right? Because again, these administrative agencies make their own rules, and with the case of these administrative courts, they're interpreting their own rules, and they bringing their own cases. And so, think of it as what you will. I mean, I think this is really a victory for the entrepreneur, our clients. I mean, we do SEC defense as well, but in most cases, it's not the deck is stacked against you because you're going against the federal government, which has unlimited resources, and oftentimes an SEC action against your client doesn't have a huge war chest to fight it, so they're looking to settle it, right? And so and that's not going to go away. But in this case, I mean, again, if they bring it before an administrative law judge, it's almost like they're both the judge and the jury and the and the enforcer or the prosecutor, right? And so, personally, I mean, again, I think the Supreme Court got it right because, again, you want to give everybody the benefit of the doubt and all the resources necessary to defend themselves, and that is, having more of an independent judge, independent jury, determine the facts of the case. And if you really did have fraud going on, then a jury would be able to flesh that out, and an independent judge would be able to flesh that out as well. So anyway, major case. It's huge, big, boom, boom. Anyway, Anyway, I thought I'd share it with you. Thanks for watching my YouTube channel. If you like this content, please feel free to like, share, and subscribe. And we'll see you on the next one. Thank you.